Good morning, friends. This is your RAPETI Suryanarayana, advocate from Visakhapatnam. In the earlier sessions, I gave many lectures with regard to various topics. All the topics are useful to the practicing advocates, law students, and to students who are appearing for judicial competitive exams and other competitive exams. Such videos are also useful to the general public for their legal awareness. Let us go to the topic. In this session, I would like to give lecture with regard to offences and their limitations to file in the court of law. This is a very important topic. Kindly pay attention. While discussing this topic, which is very useful in the general day-to-day life. For example, if there is a promissory note, there is a promissory note. What is the purpose of promissory note? If A borrows some amount from B, if A borrows some amount from B, after borrowing some amount from B, what the A will do here? A will execute a promissory note in favor of a B. A will execute a promissory note in favor of B. Okay, that is okay, clear. Okay, anyhow, A executed a promissory note in favor of B. Why? Because he borrowed some amount from B. If B did not pay any interest or principal amount, A did not pay any interest or principal amount to B, then what the B will do then? Is there any option to B? He have to go or approach to the court to file a suit on the basis of the promissory note to recover amount which he gave to B. Then, if the date of the execution of the promissory note is within 3 years, then B have a right to file a suit on the basis of such promissory note to recover from A. Otherwise, after completion of 3 years from the date of execution of promissory note by A in favor of B with regard to amount borrowed from B, after 3 years or after the lapse of 3 years period of limitation, B have no right to file a suit for recovery of amount on the basis of promissory note. That means the period of limitation for promissory note is 3 years. That means there is some period to file in a court of law on the basis of promissory note. Here the validity of promissory note or time period of promissory note is only 3 years from the date of execution of the promissory note. If 3 years time period is lapsed, then that promissory note will be treated as invalid promissory note. Why? Because the validity is only up to 3 years to file in a court of law for recovery of promissory note amount which is mentioned in the promissory note. Otherwise, after the completion of 3 years, there is no chance of file in a court of law to recover the promissory note amount which is mentioned in the promissory note. In the similar manner, if the offence is committed or is alleged to be committed or attempted to be committed, then what we have to do? Then the suffered person have to file a complaint within a certain period of limitation with regard to such offence. Within the limit of period of limitation for such offence as prescribed in the Criminal Procedure Code, if filed in the court, then the court will take cognizance or consider the complaint with regard to the such offence filed by the complainant or injured person or suffered person. Let us see in this topic whether what period of limitation is stated or given or specified to various kinds of offences as per Criminal Procedure Code. Let us see in this topic. Okay. If the offence is punishable with fine only, if the offence is punishable with fine, then what is the period of limitation to file a complaint with regard to such offence which is punishable with fine only? The period of limitation is 6 months to file in a court of law with regard to such offence which is punishable with fine only. I hope it is clear. Once again, I would like to repeat this point in a brief manner. If the offence is punishable with fine only, then the time period to file a complaint with regard to such offence in a court of law is 6 months. The time period is 6 months for the offences which are punishable with fine only. Next one. If the offences are punishable with imprisonment not exceeding 1 year. If the offences are punishable with imprisonment not exceeding 1 year, then the time period to file a complaint or case with regard to such offences is 1 year. The time period to file a complaint or case in a court of law with regard to offences punishable with imprisonment not exceeding 1 year is 1 year. The time period is 1 year for the offences punishable with imprisonment not exceeding 1 year. Next one. If the offences are punishable with imprisonment exceeding 1 year, but here condition is there, but not exceeding 3 years, then the period of limitation to file a complaint or case with regard to such type of offences in a court of law is 3 years. It means the period of limitation is 3 years if the offences punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years to file a complaint in a court of law by a suffered or injured person. I hope it is clear to all. Next one. If the offences are tried together, if the offences are tried together, then the period of limitation for filing a case or complaint in a court of law shall be determined with reference to the offense punishable with more severe punishment or most severe punishment. The time period will be determined with reference to the offences punishable with most severe or more severe punishment only in cases of offences tribal together. That means more than one offense. If more than one offences are tribal together, then the period of limitation to file a complaint or case in a court of law with reference to the offences punishable with most severe punishment or more severe punishment. I hope it is clear to all. Once again, in a brief manner, in an easy manner, I will put before you the period of limitation for the offences punishable with fine. The period of limitation for the offences punishable with fine only is 6 months. The period of limitation is 6 months to file a complaint in court of law for offences punishable with fine only. The period of limitation is 1 year to file a complaint or case in a court of law by a suffered person for offences which are punishable with imprisonment for a term not exceeding 1 year. The period of limitation is 1 year to file a complaint with regard to offences punishable with imprisonment for a term not exceeding 1 year. The period of limitation is 3 years for offences which are punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years imprisonment. Next one. The period of limitation for the offences tribal together shall be determined with references to the offense which is punishable with more severe punishment or most severe punishment. This is about offenses and their period of limitation for filing a case or complaint in a court of law. Within these periods of limitation, if the complainant or suffered person or injured person or victim files a complaint, then only the court will take cognizance with regard to such offense. After lapse of period of limitation, if the complaint is filed with regard to such offense, the court will not take into consideration or take cognizance with regard to such offense. Why? Because the period of limitation is over or expired or lapsed. It means within the period of limitation, the suffered person have to file a case or complaint in a court of law. Then only the court will take cognizance with regard to such offense. After lapse of period of limitation or expiry of period of limitation, the court will not consider or takes cognizance with regard to such offense, even though the suffered person files a case or complaint in a court of law. Why? Because the period of limitation with regard to such offenses lapsed. Before lapse of limitation only we have to file a complaint or case in court of law. If, for example, if the offense is committed in the year 2000, then injured person or suffered person files a case or complaint in the year 2020. Then the court will not accept such complaint because there is a lapse of period of limitation with regard to the offense. It is opposed to public policy. Why? Because within certain time of period or limitation, only the court will take cognizance. After lapse of period of limitation, the court will not take cognizance with regard to such offences. I hope this is lecture with regard to offences and their limitation. To file a case or suit, to file a case or complaint in a court of law. I hope it is clear to all. Kindly share my videos, like my videos and subscribe my channel. Thanks a lot.